This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why hindsight can't change policy limits, even if it's 2020. An agent for an insurer is only an order taker. He is not, or she is not, an expert that you can rely on for setting values of your property. And they have no duty to set the limit of a policyholder. It is the obligation of the policyholder. Now, Stephen and Nancy Taylor appealed the trial court's granting defendant Lake Michigan Insurance Company's motion for summary disposition and dismissing their case, and the court's denial of their motion for reconsideration. In Stephen and Nancy Taylor versus Lake Michigan Insurance Company, an August 24, 2023 decision of the Court of Appeals of Michigan, the plaintiffs alleged that the agent, Lake Michigan Insurance Company, should have required higher policy limits for the replacement of their log home. Plaintiffs had purchased the property with a log home in Bel Air, Michigan during September of 2015 for $408,000. They contacted the defendant, an independent insurance agency with whom they had previously done business, to assist them in securing homeowners insurance. Plaintiffs told the defendant's representative, Lisa Stannard, that they believed the property likely would hold a greater value in the future because they purchased it through a distressed sale. Stannard obtained information from Stephen regarding the nature of the house and input and processed that information to generate a rate comparison and replacement cost estimate, which she then uploaded into Auto Owners Insurance Company's computer system. Auto Owners had the property inspected and concluded that the house replacement cost estimate should have been $709,734. Auto Owners issued plaintiffs a homeowner's insurance policy, which they accepted without objection. The policy contained an increased cost endorsement, an ICE, that provided for payment to plaintiffs of an additional 25% if certain conditions were made. Plaintiff's house burned and they suffered a total loss. Plaintiffs submitted a claim to Auto Owners and a proof of loss which stated that plaintiffs estimated, among other things, the building damage amount of $1,282,500 and acknowledged the policy limit of $876,250, the original limit plus the ICE amount. Auto Owners advised the plaintiffs that they had paid the full policy limit, including the ICE addition, to the limits of $876,250 and closed their file. Unsatisfied with Auto Owners' settlement of their claim, plaintiffs sued defendant, the agent, essentially alleging that the defendant owed them a duty to ensure the adequacy of their homeowner's insurance policy to enable them to rebuild the house. The Court of Appeal, analyzing the issues, noted that an insurance policy constitutes a contractual agreement between the insurer and the insured. Michigan law has long presumed that one who has signed a written contract knows the nature of the instrument and understands its contents. The rule of reasonable expectations clearly has no application to unambiguous contracts. An alleged reasonable expectation cannot supersede the clear language of a contract. Under common law, an insurance agent whose principal is the insurance company owes no duty to advise a potential insured about any coverage. The general rule of no duty only changes when 1. The agent misrepresents the nature or extent of the coverage offered or provided, 2. An ambiguous request is made that requires a clarification, 3. An inquiry is made that may require advice, and the agent though he need not, gives advice that is inaccurate, or 4, the agent assumes an additional duty by either express agreement with or promise to the insured. Defendant is an independent insurance agency that serves as an agent of several insurance carriers and assists its clients in procuring insurance from those carriers. As such, the defendant owed plaintiff a duty to strictly follow their instructions. The record reflected that auto owners sent a third-party inspector to plaintiff's Bel Air property to inspect and present auto owners with the inspection report, from which auto owners adjusted upward the estimated house replacement cost. No evidence establishes that anyone affiliated with the defendant agent agreed or promised plaintiffs to assess the adequacy of their policy limits set by and offered by auto owners. The record reveals that Stephen knew the terms of the policy before accepting auto owners' offer. The trial court properly determined that there was no genuine issue of material fact that precluded granting summary disposition for the defendant. The trial court correctly determined that the defendant did not owe plaintiff a duty to assess and assure the adequacy of the homeowner's insurance coverage that plaintiff obtained from auto owners, and plaintiffs failed to establish a special relationship that gave rise to a duty to do so. In my opinion, an insurance agent transacts insurance on behalf of the insurer with the potential insured, not on behalf of the potential insured. As such, the insurer's agent is an order taker who presents the owner to its principal, the insurer. The agent owes no obligation to a potential insured to determine the appropriate replacement value of the dwelling. It, based on information from its principal, a policy limit suggested by the insurer was provided to the insured, who accepted and obtained, once there was a loss, the full policy limit after the house burned. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. Please tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos, all of which are free. And the list goes nowhere but to me. You can subscribe also to Excellence in Claims Handling at locals.com, or to my Substack publications for a very small annual fee or a $5 a month monthly fee. Please, if you found these videos to be useful, click on the like button or on the thumbs up button at rumble.com. Thank you for your attention.